lot of people think that when you sell a home as is, you're off the hook for any problems with the property. But what if I told you that selling a home as is could still leave you legally responsible for certain issues? That's right. Selling as is doesn't mean you can walk away without any responsibilities. In fact, there are some serious misconceptions about what this really means, and it's something every seller should understand before listing their property. So let's talk about what as is really means and your legal obligations when selling your home. First, let's clear up what selling your home as is actually entails. Many people think it's a magic clause that lets you sell the home in whatever condition it's in, with no consequences. You might think you can avoid disclosing known problems with the property, but that's really not how it works, especially in Massachusetts. Under Massachusetts common law, as established in Swinton v. Whitensville, which is a 1942 case, the doctrine of caveat emptor, or buyer beware, applies to real estate transactions, meaning that sellers are not automatically liable for non-disclosure of defects. In simple terms, a seller's mere silence about defects is not actionable unless it is a duty to disclose. However, there are important exceptions to this rule. If a seller is asked a direct question about the property's condition or voluntarily provides information, they're legally required to fully disclose all material facts. In Maxwell v. Ratcliffe, the courts emphasize that partial disclosure or failure to provide complete information once an inquiry is made can create liability. For instance, if a buyer asks about past water damage and the condition of a septic system, the seller must fully disclose everything they know about those systems. This means that while you might not be obligated to disclose all defects under Massachusetts common law, once you start talking about a specific issue, if you fail to provide full information, you could be held liable for misrepresentations, especially if the buyer relied on your statement to their detriment. Now, you might be thinking, what if I don't know about the problem? In that case, you're generally not responsible for disclosing issues you generally aren't aware of. However, Massachusetts law also highlights that some things like the presence of lead-based paint must always be disclosed by statute. Additionally, as seen in Waste Management of Mass versus Carver, if you engage in a profession such as environmental consultant or an inspector, you're responsible for the accuracy of the information that you provide. Ignoring the results of professional assessments or choosing not to disclose them can land you in legal trouble, as seen in the cases involving contaminated soil. Another factor to keep in mind is that while selling as is implies the buyer is accepting the property in its current condition, this doesn't protect you from claims of misrepresentation. In the Zimmerman case, a seller misrepresented the cost of repairing a septic system based on inaccurate information from an engineer. The buyers relied on this false information and later sued for misrepresentation, despite a clause in the purchase and sale agreement that indicated they had assumed responsibility for the system. The court ruled in favor of the buyers, emphasizing that even though they could have verified the information, the seller's superior knowledge about the inaccuracy of the statement made the case actionable. Statements of fact, like the one in Zimmerman, are actionable if proven false, while general statements of opinion, or puffing, are typically not. However, it's often hard to draw the line between statements of fact and opinion, which is why these cases tend to end up in court. Like Moran v. Levin provides a clear example of when puffing crosses into actionable territory. So if you're planning to sell your home as is, it's crucial to manage expectations carefully. Just because you're selling as is doesn't mean buyers will accept your house with the problems without question. Home inspections often reveal significant issues, and buyers might want to negotiate, whether that means reducing the prices or asking for a credit. And remember, buyers are more likely to trust and feel confident if the sale is transparent and you're being upfront. The key takeaway here is, selling a home as is can be a great option for some sellers, but it doesn't exempt you from all your responsibilities. You still have to be honest about the property's condition, especially if you're asked a direct question or if you have knowledge of the defect. Understanding your obligations under both common law and statutory requirements is essential for avoiding legal trouble down the road. If you're thinking about selling your home as is or have questions about your responsibilities as a seller, reach out. Let's make sure you're protected and that everything goes smoothly. Whether it's navigating disclosure requirements or understanding how to handle buyer negotiations, we're here to help you get it right.